Thank you so much, Catherine and Jeff, and thank you for having me here today. When Jeff was introducing the Constitution Project and its bipartisan mission, I was reminded of the story of Al Smith, the one-time governor of the state of New York. Some of you of a certain age may still remember him, as I do. And the story is told that he went to Sing Sing, the penitentiary in New York, to give a speech one evening, and he was accustomed to beginning his speeches by saying, "My fellow Democrats." But he wasn't sure that every inmate at the penitentiary was a Democrat, so he had a fallback line, which was to say, "My friends." But again, he wasn't really sure that every prisoner was a friend, so he had one last line, which was to say, "I'm glad to see so many of you here tonight." So I'm glad to see so many of you here, Republican or Democrat or Independent. This issue really is one that should bring us together or divide us without regard to party or partisan differences. And I'm very, very grateful for the opportunity to be with you today and to talk a little bit about this very difficult issue, difficult to be both entertaining and accurate, but by comparison to what the gentleman did down the street here, relatively manageable, even if challenging. You may recall that about a week ago, one of my colleagues, Senator Dianne Feinstein, spoke on the Senate floor to lay out a series of very alarming allegations that put the country literally on the cusp of a constitutional crisis. In a very cogent and powerful speech, Senator Feinstein described her belief that the CIA has circumvented the Senate Intelligence Committee's oversight efforts in a number of ways by stonewalling the committee's attempts to obtain certain documents, searching committee computers to monitor staff activities, surreptitiously seizing material, and most disturbingly, accusing the committee staff of criminal misconduct in an effort to intimidate them. Now, we're very early in the investigation. There may be actually several investigations underway, at least one by the Department of Justice, and I am reaching no conclusions here as to what the merits are of her allegations, but certainly when such allegations are made by someone of Senator Feinstein's stature, especially someone who has been so supportive of the Intelligence Committee, they have to be regarded as credible and significant. And they allege facts and potential violations of law that have to be addressed. Certainly, the looming issue concerns not only the violations of law that may be involved there, but also how the rule of law is really imposed on the intelligence community, which operates in secret and sometimes has shown that it seeks to operate above the law. Looming ahead is the broader question of whether the intelligence community, which has been afforded so much deference over the past decade, can operate within the apparatus of accountability that apportions power between the branches of government, as the founders sought to do. And more generally, we have to ask how much unchecked and unmonitored intelligence activity can be consistent with the rule of law. And those questions, very simply, cannot be long delayed, in part because of their urgency to maintain our constitutional values, and in part because a lot of the key statutes expire on June 1, 2015. So when you're asked, will there be legislation? Yes, there almost certainly will be legislation, or a serious attempt and a bipartisan attempt to reach legislation, because the statutes, some of the key statutes, expire on June 1, 2015. The rule of law, as we know, particularly here, has been the bedrock principle of American democracy, the lodestar of our republic. And living under the rule of law means there are certain lines that cannot be crossed. As much as a guarantee of safety might be attractive, we're not willing to pursue it if it involves abridging certain rights. In fact, under the Fourth Amendment, we are prohibited from pursuing it through a wholesale sacrifice of liberty and privacy and dignity. Police can't search houses on a hunch. As I know from my law enforcement days, there is a procedure to obtain warrants before there's a search, as maybe the CIA might have done through the FBI before it searched the committee files, if indeed it did so. And government agents can't simply listen to our conversations on the phone because they believe there may be something threatening. Arbitrary, unconstrained governmental invasion of privacy was a reason that the gentlemen, literally down the street, got together to rebel and to write the Declaration of Independence. And part of the reason was secret courts operating in secret, like the Star Chamber, which was an anathema to them, and I submit respectfully should be an anathema to us today. The FISA court is such a court, making secret law through secret opinions, in secret proceedings, in many respects, having an impact on our lives that is unknown to most Americans, but has huge consequences for the future of our nation. And part of my frustration, I will tell you right up front, is the lack of attention to these issues on the part of the American public. They seem so abstruse, technical, difficult to comprehend, and yet they are so consequential for our nation. Our current system with that secret court is the result of a committee commonly known as the Church Committee, named after Senator Church, which was formed in 1975 with hearings that revealed how the CIA secretly opened Americans' mail, engaged in campaigns of surveillance and harassment designed to discredit Vietnam War opponents and journalists, and even bugged Martin Luther King's hotel room, among other activities. And in response to these findings, Congress passed the Foreign Intelligence Surveillance Act, which we know as FISA, in 1978. FISA allows for domestic electronic surveillance when the government can show probable cause for an individual, that an individual or organization is a foreign power or an agent of a foreign power. And those are quotes from the statute. FISA also created a two-tiered court system composed of what we know as the FISA court, the Foreign Intelligence Surveillance Court, and an appellate court, the FISA Court of Review. These courts are where the government has to make its argument for surveillance or for collection of information. And the question really now is, how should the FISA court be reformed, if you agree that it should be, in a way that makes it more robust, more capable of protecting individual rights and liberties? And of course, this task is challenging because the nature of surveillance and communication has changed dramatically just in the last 2 or 3 decades. You know, again, going to the founders of our democracy who met in this very town, not far from here, the idea of the telephone would have been unimaginable, but the internet was unimaginable to us just a short time ago, and the dramatic explosion of means of information and communication would have been certainly unimaginable to the original writers of the FISA Act in 1975. So there is a task of reform, and I believe we have to address it. Again, the Act will expire, certain key elements will end in June of next year, and we have an opportunity and an obligation to address these issues. All of you know that the FISA court hears arguments from only one side. Operates in secret, hears arguments from only one side, namely the government. So the central change I've proposed is that there be a truly adversarial process, as a litigator, but really as a lawyer, anyone here who has been through the legal training, and you don't even need that training to understand, just the kitchen table is a good forum to comprehend it. The airing of debate happens best when different sides are presented. And judges generally agree. Patricia Wald, whom I questioned when she was a witness before the Judiciary Committee, said that she benefited as a judge by hearing both sides and often missed an argument if it wasn't presented. A judge's nightmare is a defendant representing himself. And judges will insist on appointing a counsel for a defendant if he or she is unrepresented. As a prosecutor, as a U.S. attorney, I dreaded defendants representing themselves because the issues could not be aired and debated and considered sufficiently without an advocate for that individual. And of course, the Supreme Court agreed in Gideon v. Wainwright, where it, in effect, disagreed with Judge McCarry, the trial judge in Mr. Gideon's case, who said that he had given every opportunity to Mr. Gideon to represent himself, to air his arguments, and he had tried to be sympathetic to those arguments. The court said he needs a lawyer, and he got a lawyer, and the result was different with the lawyer than it was the first time around. So there is a lot of practical experience that confirms this idea that the adversarial process works better when it hears from both sides, and judges reach better decisions when they hear both sides. Last summer, in one of his first comments on the metadata collection revealed by the Snowden tapes, President Obama said he believed that the FISA court would benefit from the addition of a civil liberties advocate. He was somewhat vague at the time, but I took it as confirmation that he agreed that there should be a special advocate or an adversarial process more robust than what we have now. But the form of advocate he's endorsed, I think, can be improved, and I thank him for his very thoughtful attention to this issue. But I think that the advocate can be made more effective if we, in effect, give it a certain form. As I see it, the special advocate must, for example, be able to proactively request participation in FISA court proceedings and to engage the FISA Court of Review appellate process for significant legal decisions. That would be a real reform, not just a cosmetic tweak to the current process. Giving this power to the advocate herself rather than leaving it entirely in the hands of the court to invite an advocate on occasion when the court thinks it's important is very, very important. We've heard from the Privacy and Civil Liberties Oversight Board that at least some of the judges on the FISA court believe they already have the power to call upon third parties for alternative views, but they have never exercised that power. So giving them the option or the choice is ineffective, in my view. The structure requires the advocate to make decisions about when the opposing view should be presented. And that's also why I believe that the advocate should be a permanent position with an established office and a staff, not an occasional on-call observer status that the court hears only when it chooses to do so. And so my proposal would grant the advocate many of the powers of any counsel, assert factual and legal arguments, present them to the court, and take cases through the appellate process, much as appointed public defenders do now. They are available whether or not the judge thinks a defendant needs a lawyer when the defendant needs a lawyer. And this special advocate, some may call him a constitutional advocate, would have the responsibility to protect our rights and liberties whether or not the court thought it was necessary in that case. because courts may not appreciate the importance of issues when they arise, as Patricia Wald, a very distinguished jurist, said. My proposal would bar the advocate from delaying or undercutting the FISA process. Very importantly, it requires the advocate and her staff to obtain appropriate security clearances and maintain confidentiality, just as any other member of the FISA bar would have to do. And it allows the FISA court to grant a warrant without necessarily the participation of that advocate before the proceeding. The challenge could be brought after the warrant's granted, after the surveillance is initiated, if there is an exigent circumstance that justifies the warrant being granted, much as now happens in everyday life of the criminal law across America, where the U.S. Attorney does what I did for years, and others, countless others have done, go to a judge, sometimes in the middle of the night, and have the legitimacy of the warrant tested afterward. But here, of course, there's no way of many of the targets of the warrants testing its legitimacy because they don't even know it's happening. And they won't know it's happening without there being a case in court resulting from a prosecution or some other proceeding. So the idea is that adversarial argument improves the process, protects our rights, and accountability results from it as well. Accountability also requires greater transparency. So another aspect of my special advocate proposal would require the FISA court to disclose and release decisions that constitute a significant construction or interpretation of law, a significant construction or interpretation of law, like the metadata warrant, which was never disclosed until the tapes indicated that this information was being collected. Secret law, made secretly, affecting our constitutional rights, again, we should not tolerate unless there is a greater showing that somehow our national security requires it, and then for the period of time that is necessary. The releases of this information, of the opinions and rulings of the court, could be redacted or summarized to protect classified details, but release of them and the adversarial process would accomplish a key goal. And if you agree on nothing else here today, I think we can reach a consensus that confidence and trust has been eroded and needs to be restored. Obviously, the Snowden tapes have played a significant role, but the American public needs the assurance that the rule of law will be more than a phrase when it comes to intelligence gathering. Public trust also comes from appearance and perception, not just the reality, of a balanced and unbiased court making these decisions. Unlike other courts, the judges of the FISA court are all appointed by the Chief Justice of the United States Supreme Court without any oversight or confirmation. They're all Article III judges, so they've all been confirmed by the Senate as well as appointed by the President, but not for this role. And again, without any disrespect, without a scintilla of disrespect for the Supreme Court or the Chief Justice of the United States, Americans may hesitate to trust a court whose members are picked entirely by one man without any kind of review. None. No review whatsoever. A court picked by one man will inevitably be more homogeneous, less diverse ideologically, as well as in background, than one assembled by multiple sources. And extensive research has in fact shown that judicial decision-making is negatively affected by homogeneity. And that's why we have different kinds of people, different ethnic and religious and economic backgrounds serving on our court, and the move toward greater diversity is one that I have supported passionately and aggressively, and fortunately this president has done as well. And that applies to ideological perspective as well. Adversarial process and protection of liberties is best guaranteed by that diversity of viewpoint. That's why my proposal to reform the court focuses on its composition. The FISA Judge Selection Reform Act authorizes the chief judge of each judicial district to appoint a member of the FISA court subject to review and approval by the Chief Justice. It's really a pretty modest change when you come right down to it. After all the rhetoric is stripped away, it is a very modest change because we want to preserve the confidentiality of the court, and we want to, in my view, stick to judges who've already been confirmed. The alternative of having them reconfirmed, I think, raises the danger of politicizing the process, and I'm very sensitive to that concern. This reform, though, would ensure that the judges on the FISA court represent the broad mainstream of judicial opinion. And it's designed to give greater diversity on the FISA courts without undermining their independence from political pressures from Congress or the President or anyone else. Let me close by saying something that I think goes without saying. I have the deepest respect for our intelligence community. They are dedicated, patriotic, able Americans who serve, sometimes in harm's way, with great courage. And they perform a vital mission for our country. I have two sons who've been in the military, one in the Marine Corps Reserve serving in Afghanistan. He's back now, and he's in law school. Another son who is a Navy officer in training out on the West Coast. I'm a member of the Armed Services Committee, as well as the Veterans Affairs Committee. I know well and appreciate deeply the threats this country faces and the courage of men and women in uniform and out of uniform who serve in our diplomatic service as well as our military, and the ways they benefit from the intelligence that is gathered by the agencies that too often we take for granted and too often we criticize unfairly. I am sympathetic to the challenges they face. And I want to make this system worthy of them. I want to make it the best it can be, just as we expect them to be the best they can be. Our intelligence community and our legal framework must be not only worthy of them, but worthy of this place and of the Constitution that it symbolizes, and the rights of privacy, speech, assembly that here today we exemplify. And I believe that it is possible and necessary to achieve those ends. I believe it because of my years in the courtroom, not only as a prosecutor, but as a defense attorney, and my days in the legislature, because our values and ideals don't disappear simply because of enemies like Al-Qaeda. In fact, really, when you think about it, the threat of Al-Qaeda makes those values and ideals all the more important. It is what those brave men and women seek to uphold when they put themselves in harm's way. They're the reason that we're here today. And by undercutting or undermining them, we make the system unworthy of them. Those are high ideals, and I know there's hard work to do to match the system with those ideals. And your work today, your dedication to those ideals, bringing us together today, are very much appreciated, and I'm personally grateful for this opportunity to be here. Thank you. And I'm happy to take a couple of questions. You have a really smart panel ahead, so I'm not going to take too long. Yes, sir.
Yeah. Two questions. First off, where is the FISA court at?
It is in Washington, D.C. If you're referring physically where it is, it's in Washington, D.C. The judges come to Washington, D.C.
Okay. The second question is, most Americans can tell you who's on Dancing with the Stars or who won The Voice or who's on Walking Dead or anything like that, but they can't tell you anything about the FISA court. Do you view the mainstream media as more of a distraction to keeping, how should I say, the public dumbed down? They're not interested in the FISA court. They're interested in what's going to be on TV or who's been eliminated from this game show or something like that.
All of us really bear a share of responsibility for the lack of public attention to important details like that one. Who's on the court? Where do they come from? There have been some good journalism. There have been good reporting on the FISA court that indicated the homogeneity of the backgrounds of the individuals. It's a matter of public record. So I don't blame any one in particular. I think it is a failing that all of us have to address. And one way to do it is through this kind of forum. And I think that's why it's so important.
I totally agree with you on adversarial procedures are critical, but in security issues, isn't time very critical? And would the introduction of an advocate slow the process?
Another good question, and I may not have been clear about it, but again, no delay should result from this adversarial process. The challenge to a particular warrant could and probably would be done in a lot of instances after the warrant is granted. Remember, right now, as a prosecutor, I go to a judge in his office, or I go to a grand jury behind closed doors. They grant me the power to search or surveil, whether it is a physical break-in, for lack of a better term, a physical entry is more accurate, or some kind of surveillance. And then that act by the government is tested later. The same principle would apply here. It could be completely in secret, but the advocate, the constitutional advocate or special advocate, could and would challenge a ruling by the FISA court, either before the court, after it made its decision, or possibly on review. And then the issue of, for example, is the broad collection of telephone numbers, all telephone numbers of every American, authorized by the statute? Is there sufficient need for it that it would be justified under the statute? All of those legal contentions could be tested and argued through the adversarial process. But in the meantime, if there was a need for the government to be surveilling an individual planning some terrorist act, that surveillance could go forward. So your question is well taken. It is a point that has to be addressed. And if that's not the way to do it, some other way ought to be devised. I have no pride of authorship over any of these specific. If somebody has a better way to do it, I welcome it. I simply think that there ought to be an institutional place for the advocate to be on a full-time basis with the power to raise issues at some point that guarantees our rights as well as our security.
Thank you for being here, Senator. You mentioned Snowden, for whom some people see as a villain, some people see as a hero. What do you think of allowing a court or the FISA court to be open to third parties who have a desire to disclose what they believe is illegal government activity, and having the court rule on whether or not that disclosure would be protected? And if it were, then the person would not be subject to criminal penalties.
I think that's a separate sort of set of issues that may need to be addressed. I'd want to see exactly how the system would operate. If there are complaints about law breaking, in effect whistleblowing, and they could be brought to the FISA court through an advocate, a special advocate or a constitutional advocate, that might be a means to do so. But the main purpose of this advocate really is to forestall violations of rights that later would be the subject of complaints by a whistleblower. In other words, much better to prevent any questionable legal activity before it occurs than have it be the reason that a whistleblower comes forward. But whistleblowing is a deeply established and rightly esteemed tradition in our government. As Attorney General, I came to know firsthand the importance of whistleblowers in protecting our rights, and we need to guarantee that they are not subject to either retaliation or some other kind of bad action as a result of their blowing the whistle. I'm referring to whistleblowing in general, not to Snowden. And nothing I say here should be interpreted as condoning or approving what he did. Yes, sir.
Well, Justice Jackson said that the Constitution's not a suicide pact. One of the things within the Constitution, however, is to let the sun shine in as a means of cleansing. Would you consider putting a requirement in that over time that the cases before the FISA court would be reported?
I think reporting of cases, disclosure of rulings should be done when possible and when the rulings merit it, regardless of time, and be done in a way that preserves security. Redacting classified information, maybe in effect summarizing the rulings of the court so that they could be raised in other kinds of challenges. You can't know whether rights have been impinged in the world of electronic communication without the court, in effect, giving some indication that it's been done. You know, the Fourth Amendment was framed at a time when generally there were actually physical witnesses to the English soldiers breaking down a door and rummaging through a person's house or taking someone into custody or some other violation of what the colonialists, the founders, thought was their basic rights as Englishmen. You know, it wasn't that they thought these rights were novel or original. They're the rights of people who live in a free country, which they thought they did as citizens of the colonies of England. And so they were just saying, we want to protect the rights we think we have right now. Well, those rights are no longer protected or impinged by physical action. You know, you think of the electronic world and all that can be done invisibly and secretly, and it is really mind-boggling. And so we need to match that challenge with a court that issues opinions, when it can do so, consistent with our security. You wouldn't want the court saying, we just authorized a surveillance on so-and-so who we think is about to blow up a building or take over a plane or whatever. I mean, I'm really stating the obvious to all of you, and even though these principles seem obvious, they're much more difficult to enshrine in words. Thank you.